Hey guys, in about 4 minutes, they're going to be having a live discussion about the Bryan Kohberger case. Let's tune in live, guys. Hey there, we're getting ready to go live for the live discussion on the Bryan Kohberger case. That starts in 4 minutes, guys.
Our show. I'm Jesse Weber. Thanks for joining us. I'm happy to be with all of you. We have something special for you today. So I was thinking about this New Year lot, and I was thinking, what is the big trial, right? What is the case that I wanted to talk to all of you about? What's the Alec Murdaugh trial of this year? The Johnny Depp, Amber Heard trial of this year? You gotta say it's Bryan Kohberger out of Idaho, right? Because we don't have a trial date set as of yet, but prosecutor Bill Thompson is hoping for this summer to have an actual trial. And I don't need to tell you how massive of a trial that will be. I mean, you have a case about basically a stranger, a grad student accused of brutally murdering 4 University of Idaho students in an off-campus rental home. It's insane. It's disturbing. And what I want to do is I want to hear your opinions on the Bryan Kohberger case and all the mysteries surrounding it. The deaths of Madison Mogen, Ethan Chapin, Zana Kernodle, Haley Gonsalves. You see, I believe there are a number of factors at play here, because one is the idea of the stranger in the night breaking in, committing a vicious killing. It's the stuff of nightmares. It's one of those crimes that really sit with you. It's one of those crimes that we worry about the most in true crime. And the why, right? So if Kohberger did this, why did he do it? I'm hoping that we're going to get more answers from the prosecution at trial. They may reveal more about a potential motive. And yeah, I know. I say it all the time. Motive is not an element of a crime. The prosecution doesn't have to prove motive. But I will tell you, it sure helps sell a story to a jury. So I imagine we're going to hear more at trial. And with the gag order in place in this case, there's so much that we just don't know about what happened. But one of the most important questions, and I would love to hear all of your thoughts on it. And it's the most important question in my view. Do you think Bryan Kohberger will be found guilty? If you believe he did it, can the prosecution prove it? Do they have the evidence? Does the defense have tricks up their sleeves? Now, here's how all this is going to work. So you're going to share your thoughts and your comments on the Kohberger case in our live chat. And I'm going to be taking your questions, your opinions here on the air live. Now, to make sure your question or comment doesn't get lost in the mix and in the discussion, you can send a super chat our way. We're going to make sure it gets addressed right here. Super chats are really the best way to get your message noticed. So as we get that started up, and I really can't wait to hear from all of you, a lot to discuss today. I want to bring in, we're also going to bring in special guests during this hour. So first up, you know, long crime reporter, host of Crime Fix, the very own Anjanette Levy is with us. Hey, Anjanette, how you doing?
Hey, Jesse, I'm well. How are you?
Good, good, good. So Bryan Kohberger, I'm sure you've heard of the case. You're a resident expert. You were there when this first broke down. What's the latest? I mean, what is an issue that you see coming up in this case that you wanted to talk about?
Well, you know, there are several issues, Jesse. First of all, is the trial date, but really, interesting issue that's coming up, I think, that's coming up very soon is the fact that the defense in this case suddenly wants motions regarding their request to have the case thrown out, at least to have the grand jury indictment thrown out. They want it unsealed. They want the public to see it. And they want the hearing that is supposed to be sealed regarding their request, their renewed request to have the motion or the indictment thrown out.
Yeah.
They want that to be open to the public. This is all very new and refreshing to a lot of us because the defense in this case has continually throughout the duration of this case said we want a gag order. We want to file motions under seal. We don't want cameras in the courtroom. But now they're saying because this motion was denied and because it's already been discussed, they want the public to see it. So I think this is an interesting turn of events because everything that they've filed for the most part in this case has been filed under seal. Up until this point. So
I don't think it's going anywhere.
Whether or not the
you could disagree with me, Anjanette. I don't think this is going anywhere. And just to be clear and make it clear for the audience what's going on here. So the defense, right, you said they want to unseal for the public. They want the public to know the arguments they made to the judge about why he should rethink his position to not throw out the case, to not throw out the charges. They want their points made public, right? And they've said that the only reason that they wanted anything sealed in the first place is because that's what the prosecution was. Now, I don't.
Hey guys, I got some breaking
The
news.
judge here, John Judge, that's his name, will necessarily.
Richard
I
Allen's
can't think of a better
attorneys are speaking right now in front of the Supreme Court. I'm going to go to that
It seems to me
instead of covering this.
would want to do is change the public narrative because there's been so much said about him. This would be an opportunity.
This morning, to argue in the case of State Terrell Richard Allen Relator versus Carroll Circuit Court and the
This is live right now, guys.
Respondent. Counsel for Richard Allen, the Relator, will argue first. We're hearing this case on a writ for mandamus and a prohibition case. Representing the Relator today, we have Mark Lehman. Good morning. Welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winnicky. Good morning, Ms. Winnicky, and Bernice Corley. Good morning. Welcome, Bernice Corley. Representing the state of Indiana, council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the agenda. Got that. So Matt Dupline, representing Judge Fran Galt, and you'll be arguing first. And at council table, we also have Chris Stake, who's also here on behalf of respondent. Correct. Good morning and welcome, Mr. Stake, and council. Councils, we've been conducting oral arguments. You'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes. So you ready to proceed? I am. All right, Mr. Lehman.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that the court intervene and invoke its inherent authority.
See what you guys think's going on in the Delphi case.
On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review, this behind the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes, and his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these
Okay,
circumstances.
but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons. If they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion in the trial court judge has.
There's an absolute duty to follow the client's wishes. And then when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary
And
decision.
the absolute duty is found under the Sixth Amendment.
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this, constitutes three situations where in their totality, they clearly place the limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record that had preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that.
You have a lot of concerns, but I've got you got a lot of concerns and you do a nice job laying those out in your brief, but there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third final time.
So they sat on it they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor, they had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen and with Wynn specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates State's Attorneys Baldwin and Rosie, and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants Attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on, was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues
But
don't
maybe
involve.
if there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed
What concern? Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceedings.
What do you guys think about what's going on there in Delphi? Let me know in the comments.
Built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regard to disclosure of the Westerman's material. He filed with the judge, says, I'm aware of that. I know what's happening. I'm ready to ride.
I'm asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the West, if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under the court's case law. You bring the defendant into chambers, you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interest, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counselor, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing.
Since when in the history of court, guys,
with ineffectiveness
has
trial counsel at trial? Ineffectiveness is not coextensive with
a judge stripped away a defendant's attorneys? That's never been done before. Hey, Chief.
Negligent incompetence. I don't know if it was about trial representation at all. And then the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
Yes, Judge.
that's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, Interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winnicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Baldwin and Rosie, who he'd been working with for over a year to develop and get ready to get that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing.
I don't think we would have had a full record even then, Judge. The judge was saying that there was the coercive action, the judge. I'm going to go out there and I'm going to say these things, and Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe, Your
Because you're
Honor,
saying there's not enough for this. But there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
correct, Your Honor. I do think I don't think
Got a
those
hearing.
positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the
So
60
my
minutes
concern is getting
require.
this case back on track.
Yes.
All right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error, it'd be reversed, and everybody would have to go through this again, correct?
Yes. Judge, but I do want to clarify that this is more than just a choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off
A
the case.
lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant. With regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your at this point, a court-appointed counsel. I do not think you're going to fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland effective assistance of counsel and say, my attorneys were not effective. I mean, I lost because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point. They're
Not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, was literally going behind the scenes, talking to co-defendants who are represented, trying to manipulate their testimony, the judge at that point just proceeds forward the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think there are rules that an actual conflict of interest is unwaivable when you sue one party versus the other. And shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, other than that one rare exception.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask you this way. If we grant you the relief you're requesting, we reinstate counsel. And Mr. Allen's convicted. Can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those. No, I'm going to change that, Justice. No, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago, and in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waivered. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial, and that fully and fairly advise him that's a repercussion. But if when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
well, counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge? Or are you saying if the judge finds it, she still can't remove him?
Well, this record does not support ineffective assistance to counsel.
But even if it did,
no, sorry. the reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that a law that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did have nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in, goes into the chambers and said, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of ethical rules, that there's a disciplinary proceedings that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case, it'd be a conflict of interest. So we're struggling to find a situation.
Yeah, this is the first time that has ever happened in judicial history. A judge stripping a defendant's lawyers and then having to go to the Supreme Court to get them reinstated.
And the judge somehow has a role, absent a conflict of interest, in injecting herself into that. And I do think that you can waive, you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations. Not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples, these are good examples of that. And that the inadvertent disclosure of pretrial discovery has not, the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin.
Okay, I'm going to go live on a different studio that's more stable.
Just to sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason